The problem is a lot of times when they're using LegalZoom, there's something not done correctly. I mean, they've done all the right intentions of trying to set up this will, and either they don't execute it properly, which is automatically that will doesn't matter.
So today's guest is Lia Rauber. She's an attorney and founder of the law offices of Lia Rauber PLLC in Sevierville, Tennessee. An East Tennessee native, she represents clients throughout the region, focusing on estate planning, probate administration, real estate, and civil litigation. She is dedicated to helping clients navigate complex property matters, wills, and difficult transitions. So, difficult transitions, probate, we are familiar with it. So, why did you decide, hey, I'm going to be an attorney and I'm going to go into the probate business? Tell me a little bit about it. Thanks for being on there, on here with us first. So, I really appreciate taking your time.
Thank you for having me, Chad. Yeah, I went to school at University of Tennessee Law, and during the wills clinic, which I had signed up for because I thought I might have an interest in this area. Once I was in that wills clinic, I knew for sure, because honestly, I don't know why more lawyers don't do this type of law, because you're helping people. There's not only so many things in the legal arena where you're not just fighting people all the time, and this is the one area where really what I'm doing is preparing families, helping people through some of the worst times of their lives, of course, the death of a loved one. And I found a real passion for it, and I've been lucky enough. I'm in 11 years in, and I've practiced this pretty much solely since I started, and I love it. I feel like it serves a purpose, and I just enjoy getting people through these periods and thinking about, what do they say? Everybody is going to face death and taxes. Is that the saying? But it's the truth. I mean, we all have got to deal with it, as hard as it is to think about. Everybody's going to have to deal with it. So it's one of those things I enjoy
Two
helping
things
people.
are two things are certain in life, and that's death and taxes. That's for
That's
sure.
exactly what it is, right?
So I'm 50, getting ready to be 51 here in August. Tell me how important it is to have a will.
Well, and I'm glad that you brought that up, because in my 11 years, I was telling a client this the other day, I would say, under 40, I have maybe had 10 couples, 10 married couples. It's that few. Because the reality of it is most of the people that are coming to me for estate planning are 70, maybe 80s, 70s, 80s up. And what I want to really get a message out about is that I think a lot of people think, well, hey, all I have is a house with a big mortgage on it, and I've got 25 years left on it, and, I've got a little money in my bank, and I have cars, I don't need a will. Really, any person that has, especially a child, with anybody, should have a will. Because even if you don't think you have a lot of money, if something happens to you and your spouse, and something, tragic were to happen, you're going to have a real situation if you leave a minor child, even if it's just a house with a big mortgage on it. If you've got a will, you can actually say, who's going to control this money until this child reaches a certain age? Which is super important, because I'll tell you, I think a lot of people don't think an 18-year-old should inherit money outright. And if you don't have that will, then guess what? Your 18-year-old could either inherit a life insurance, possibly outright, a house with a mortgage, having to make a decision like that. So, I mean, it is so important that you have something in place just for the what if. And what I also tell people a lot is, your circumstances are probably greatly going to change. Even you right now, you said you're 51, hopefully by the time you're in your 70s, you're going to have a lot more money. That would be the great thing.
Well, I hope, and my kids will hope so as well, for sure.
Exactly, exactly. They're praying for it. But the thing about estate planning is, with most of the tools, it is all revocable, changeable, easy to change. So you just, they call it the last will and testament because it's the last will you do before you pass. And what that implies is, hey, if you want to change your will every month, I mean, that would be good for my business. Come back and see me every month and I'll update your will. But there's nothing, as long as you have competency, you can change your will. So I just think with younger, people my age, I just turned 37 and I have one child with my husband. I would say, rarely any of my friends in the same situation have a will. But if you at least get a simple will in place, I've got set out what could happen in the rare event that something happened to both me and my spouse, and my child would be protected.
Right. I think there's just a stigma that goes along with, if I'm doing a will, then that means, we're getting ready to die or something. But, we do a lot of estate work here. And if you die without a will, and we're dealing with one right now, it's horrible. It's not, I mean, it's just horrible for the family, for everybody involved. So we have you'll appreciate this. We have an estate right now with 25 heirs.
Oh no.
Well,
Oh.
have any kids, so they died. So 25 heirs that we deal with. So
Yeah, that's the thing. I mean, especially people, because really what happens if you pass without a will and if you haven't done any estate planning, then your property is going to pass through something called intestate default laws. And it's essentially a structure that the state you live in has set out that this is who's going to inherit if you don't have a will. So yeah, people with no children, and especially if their parents have passed and then maybe their siblings have passed, and then it goes to the nephews and nieces or the cousins. I had an estate once that had about 60 heirs, and it was only one piece of property that then, so it was the worst headache to try because to get something like that sold, even though there's 60 heirs, they all own an interest in that real estate. So when you go to sell it, which you're finding that out right now, you have to give them the proper notice, the chance to contest. I mean, it is a mess. So rather than just having something in place. So,
so
yeah.
you've had a case with 60 heirs. We had one a couple years ago with 29, and it took us forever to get it closed out. But so what's the worst thing you've seen in this business so far? As
I
far
mean, I will tell you one thing that I think is going to be even a bigger problem going forward is, I mean, something we've dealt with for a while in this area is online wills. I mean, that's been around a while. There's been LegalZoom. And what's kind of surprising about that is I think people have a misconception about how expensive an attorney would be compared to LegalZoom. What I've found, at least with my prices, it's not even that big of a difference of what you're paying.
right.
But the problem is a lot of times when they're using LegalZoom, there's something not done correctly. I mean, they've done all the right intentions of trying to set up this will, and either they don't execute it properly, which is automatically that will doesn't matter. If you didn't do it correctly with two witnesses and the notary and having everything as it's supposed to be, then it's like you didn't do a will. So we're seeing a lot of issues with that. And then I think what's even going to be a bigger issue is with, of course, all the AI and the chat GPT. If you go on there right now, you could say, hey, make me a will, and it'll come up with something. The problem is, I don't think that people are going to still understand what the will says, because ChatGPT is not going to be able to, at this point, fully address what your issues are and explain to you what these different words mean. I mean, it's going to be really interesting. I had some man that I just met the other day. He asked me what I did for a job, and I said, I'm an estate planning attorney, probate attorney. He said, what are you going to do in 5 years when you don't have a job? Talking about AI to me. And I said, well, thank you, sir.
Yeah.
But we've been dealing with online wills for way longer than this, and I still think it's not going to change the fact that a human needs somebody to explain to them all the different facets of it. And yes, AI is good, but I don't think it's ever going to be able to fully explain what you're doing. So what I would say to people, at least this is what I do. I do a free initial consultation where I will at least talk with people, explain to them a couple of things, tell them what they need. And then usually you can get a quote ahead of time, and then you can decide, hey, is this worth it for me to move forward? And I think there's a big misconception about what you would pay an attorney if you get the right attorney that's not taking advantage of you, I guess.
Yeah. I've been in business for a while now, and I've learned, good things are not cheap, and cheap things sometimes aren't good. So a good attorney will go a long ways for sure. So
It's a great point. Yeah, and that's the thing too. I will say, I would my advice too would be go to an attorney that actually does this area, because sometimes you have the general practitioners that'll take on a will, but it is so important to make sure you have everything correct. And one thing I wanted to bring up for sure, because this is a big common misconception. Sometimes people say to me, well, I got a will done so I don't have to go through probate. And I'm assuming you probably, I'll get a lot of probate and estate questions in your line of work. People don't understand what it is, and they think, well, they think, oh, I've got a will, I'm good to go.
Mm-hmm.
That is not the determination of whether your estate's going to go through probate.
Let's touch on that real quick. Tell us a little bit about probate and how it's changed in the last couple of years in the state of
Yeah,
Kentucky. So,
yeah. So probate itself, what probate really is it's opening up an estate in the county you're domiciled in, your resident county, and it's opening up an estate, and the probate itself is the administration of the estate. And the determination of whether you're going to have to file a, well, you won't have to do it because you'll be passed, but whether your family has to file a probate for you for your estate is how the assets pass upon your death. So a lot of times the typical situation is a married couple that they've got joint ownership, like they're both on the deed to the house, they're both on the cars, they're both on bank accounts. A lot of times when one of the spouse passes, as long as everything's jointly owned, there will be no probate filed upon that first spouse passing, which is a good thing because, when a spouse loses a spouse, you don't want the spouse surviving to have to file anything or do anything. And in Tennessee, we have a type of law called tenancy by the entirety that allows spouses the joint ownership to have automatic survivorship. So even doesn't really matter if you have wills at that point. If you have joint ownership, the first spouse passes, nothing needs to be filed. However, if you both passed, if something tragic happened, like a car wreck or something, or upon the second spouse passing, then there would be a probate filed because that type of ownership that I'm talking about, tenancy by the entirety, doesn't pass to children. So it's a special type of ownership between spouse. So if the second spouse is passed and say there's a normal estate, a house and cars, then at that point, the children will have to open up an estate, and part of opening up an estate, one of the things you say is whether mama or dada had a will. That's part of it. And so no matter if they had a will or not, the estate's going to get open. If they had a will, the will is going to say who inherited. And, one of the things too that surprises people, that people say to me all the time, well, you have to give to your kids, don't you? Well, no, you do not. So you can give to, if you do a will, you can give it to whoever you want. You say my kid can get $1. But anyway, that will is filed and that says who the property would go to. And if mom or dad didn't have a will, then the estate is still filed, a probate is still open, and it passes through that intestate default law, like I said before, which if there's like 3 children, it goes to the 3 children, if none of them have passed. But yeah, I think that really probate, I would say, gets a little bit of a worse rap than it's due. That's my where at least where I practice in Sevier County primarily. People think it's this long, drawn out process that you're doing stuff all the time. And I would say, you're looking at about usually 6 months minimum. And that's because of a thing called a creditor period, where creditors are given 4 months to file a claim. So that means you can't open up an estate and close it
yeah, a lot of people don't
automatically.
understand, that we deal with that, when mom and dad dies, a lot of times they come in, they're ready to sell everything, and they just don't understand why they can't get the money right now, so.
Exactly.
And that
And
goes, you need you a good attorney, and you're here to do that. That's right.
that's right. And yeah, I mean, I get that question a lot too. Like, why can't I just go ahead and sell? And a lot of times, they may be able to still sell, but that money may not be dispersed, right?
Yeah.
It may be held in escrow. Even though if there's no creditors, there's still a certain amount of time that they're given time to file a claim.
Right. Yeah. That's
Yeah.
we run into that a lot. We work for different attorneys and stuff, and they don't explain that just because we're selling the land don't mean they can cash out at that time. Sometimes. So hey, so in our area we deal with a lot of commercial properties a lot of times and a lot of investment properties. Can you elaborate just a little bit on what happens if you're invested into a property with a partner and you pass away? What's your family? How does that all work for people that might be interested in getting into investments and stuff? How they need to have it set up?
Yeah.
into
So
that?
it really is going to matter how you are, what kind of, is there a partnership agreement? Is it an LLC? That's obviously, there, a lot of LLCs, maybe there's just two people in the LLCs and the properties, and a limited liability company LLC. And so it's really going to matter if they've got some kind of operating agreement that's already saying what happens if one of the, investors passes. If that's set up, that could override anything that a will or anything else you've done. But I would say a lot of times what I see is most people that are in investments, it's just treated as their personal property. So it could be a situation. I think that's very important when you're going to work with somebody. You need to have that conversation with your partner and say, realistically, what does this look like if one of us passes? Because you could have a situation where you are all of a sudden in business with your partner's spouse and four kids, and then they're going to own 50% of this property, which means that they're going to be involved in all your decision making. Really could complicate things. So that's a really great point that people need to really look and always prepare for what would happen there. So
Right.
yeah,
That's have a good understanding on the front end, so you don't have a bad understanding on the back end, right?
that's exactly right.
So how about wills and minor children? Let's move on to that. Why is it an absolute rule that if you have a minor child, you must have a will, or you need to have a will for sure?
Yeah, I kind of touched on that before, and let me just say this again because I think a lot of times people that have maybe minor children, that maybe they're not where they want to be in life, and they may think that their estate's not large enough to have a will. But especially if you have a life insurance policy, any type of real estate, even if it has a mortgage on it, anything that could possibly pass to a minor child, if you and your spouse were both to pass, then having a will allows you to appoint somebody, what I call it's called a testamentary trustee. So it's essentially a trust set up through your will that says that, hey, if my spouse and I pass before my child reaches a certain age, then this is who I would appoint to handle the real any inheritance that minor child would get. And because we all know, a minor kid can't sell real estate. A 7-year-old can't agree to sell a home even if it's subject to a mortgage. So what that allows is to already have somebody in place that can, has to be somebody, of course, you really trust, but somebody that would make those decisions and also be able to distribute assets to the child if needed. The basic terms are, it's like for the health, support, education, maintenance of the minor child, that trustee could have discretion to distribute before they reach the age. And so it allows that, really allows access to the funds, but also protects the assets so that you can decide when you would want that child to actually inherit. And like I said before, most people don't want an 18-year-old to inherit everything that they could. And so a lot of times my clients either say 25 or even age 30.
Right.
I mean, at this age, sometimes you don't know. I mean, sometimes it's better to let not give full access, especially depending on the size of your estate.
Right. Yeah.
And the other thing I want to say, there's a common misconception out there about you can appoint a guardian for your minor child through a will. You can't actually do that. What you can do is recommend who you'd want to be a guardian of your minor child. So again, guardian is actually, that's dealing with custody. That's who would have actually, uh, that doesn't have to do with who would have control of the money. If you've done a testamentary trustee, you could actually appoint different people. So you could have somebody kind of over the money and then somebody that you would recommend to be the guardian. But what it is you and your spouse can say in your will, hey, if something happened to both of us and my child is still a minor, here's who I would recommend would be the guardian. And then if you were to tragically pass like that, what actually happens is a court is the one that's going to make that decision because they're going to review all the circumstances, all the family members, to decide who is in the best interest of the child should take them. But a lot of times, the judge, the court is going to really look at, well, here's the will. And here's where mom and dad said they want this aunt to be the, to take custody. So they'll take that really into account.
That's me and my wife and I. We were missionaries in Honduras, and before we went to before we went to Honduras years ago, we had to have a will, and we kind of had to point that out too if something happens to us. And so, if we had a will, how important is it to keep your will updated? I guess. Because, we haven't touched our will in 15 years now.
I would say definitely it needs to be, I don't know if I'd set a time limit on it. I think the main thing is if you buy new property
Right.
or if circumstances change, obviously, if somebody passes, if your wife passed or something, if your spouse passed, you'd want to look at your will and say, is this still what I want? Or, with your minor children, what you could have put back then, you probably appointed somebody in these roles I'm talking about, trustee and a guardian. So you might want to look back and say, hey, is this still the same people I would want to appoint? Or, is
Really
there
trust
something?
my brother now. That's what I need to think about. Do I really trust him to raise my kids?
That's right, because and that's the thing. Like I said before, all of these documents that we've talked about so far are changeable and updatable. So you do something, and then circumstances change. Hey, you change the person you appoint. But just as hard as it is to think about, I like to tell my clients, if something happened to, you need to think, if something happened to me next week, what would I want? And just focus on that, because we never know what's going to come in the future. Or you may have a child that is just super responsible at age 19, and you say, hey, you know what? I'm going to go and change my will that if I were to pass, they'd inherit everything.
Hmm.
So
I'm keeping it 35. I don't think my kids will be responsible until they're about 35. So
no, I think it's true. I don't know when the brains develop, but it's definitely not 18. I can
it's
tell you
not
that.
18 or 20, I don't think.
Not this generation behind us, right?
No, I don't think so. Hey, so I was telling you about we're dealing with a property up in Ohio, and it's a trust. So it has all kinds of properties in this trust. Do you work with trust, and can you tell us a little bit about it or the benefits and stuff? If you do.
Yeah. I'm glad we're talking about that, because I think trust seems to be such a buzzword nowadays. I have a lot of people that call me and say, hey, I want a living trust. I want a revocable trust set up. And there's a lot of misconceptions about what a trust can actually give you. So if you're actually doing a revocable living trust, what that can do is, if you've put all of your property into it, the one benefit that gives you is your heirs can avoid probate. So it allows an automatic transfer of those assets to whoever your beneficiaries of your living trust are, just so they don't have to do that process I was talking about before, as far as filing, with the court clerk to open up an estate, going through that 6-month process. And as I told you, I think probate gets a worse rap than it's due. So a lot of times I'll explain that to people. And I mean, you almost go through more work up front to set up your revocable living trust than your heirs would, maybe even through a probate. Because setting up the revocable trust, you've got to, you're doing a deed your property into it. It's just a more complex legal document compared to a will. I mean, you've got more, like, I would say altogether about 65 pages compared to maybe 4 pages, because you've got about 7 or 8 correlating documents with your trust. Now, for some people, they don't want their kid to have to do a thing when they pass. And so, hey, that revocable living trust, that's a move. And then they want to make it super easy on them, so they go through it. But what a lot of people think is that living trust gives creditor protection, that it gives, I mean, that's the big thing. Well, taxes, ever since I've been practicing, has rarely been an issue for people unless they have a whole lot of money now, inheritance taxes, because of where we live.
Mhm.
So I would say trust used to make a lot more sense, obviously, when, of course, nobody wants to pay an inheritance tax. But now in Tennessee, our inheritance tax is completely abolished, meaning you can pass with 50 million and not have to pay the state of Tennessee any inheritance tax. And then federally, it's raising and probably going to get raised again, but it's roughly, 15 million for an individual before they would federally owe an inheritance tax. So the reality of it is rarely any of my clients are dealing with that type of money. So there's no inheritance tax protection. So there's no creditor protection with the living trust, because really the trust trust does get kind of complicated. But I always say the rule of thumb on it: if it's a revocable trust, meaning you still have really control over your property, if you decide to take it out of the trust, if you have control over your property, creditors can still access it. Really the only time you can get creditor protection is if you do some kind of irrevocable trust, where you really put it into a third party qualified trustee's hands. So and of course, irrevocable is like it sounds. It's harder to get out of it. You're actually kind of already giving it to your beneficiaries. That can give you more protection, but a lot of times people don't want to make that decision because they may want to change their mind about what they want to do with their real estate.
Now, can you have debt on property and put it in a trust?
So it depends on, there's so many different types of trust. And to be honest, I don't want to tell you anything wrong about that. So that maybe not be a question I'm qualified to answer for you. But I think the short answer would be yes, you could if you did it a certain way.
Okay.
I mean, I really don't do, in my practice, I don't do trust as much as I do wills because of the things I just said to you.
Right. A lot of it does seem like it, like you said, it's a buzzword. There's a lot of people in my little network who's, you need to get a trust. You need to get a trust.
Hmm.
I'm like, I don't need to get. I'm so indebted. I've got tons of property, but I owe on everything. So I'm not going to fit. But my kids, they're going to really love me when I'm dead and gone one day.
That's right. Exactly.
How about power of attorney? How important is it to having a power of an attorney?
Yeah. So
I guess it's
power of attorney, and that's different. We're kind of switching gears on that because I think sometimes people don't even know what that means, but that it doesn't have to do with your death. Power of attorney has to do with while you're living, if you're ever incapacitated. And they're super important documents. I mean, they're pretty standard documents, but it's allowing you to say, if I'm ever in a situation where I'm incapacitated, this is who makes decisions for me. And different attorneys do it different ways. I set it up in two different documents. I do a healthcare power of attorney and then a financial general durable. So, like it sounds, healthcare, say I'm in the hospital and what if I'm just even having a surgery and I'm put under and somebody need to make a decision for me? That power of attorney makes medical decisions on my behalf. And then the financial is a lot more power. You have to have a lot more trust. That would be if a doctor has deemed you incapacitated, then that person can do pretty much anything you can do for yourself. I mean, that's how a general one is set out. So they could sell real estate on your behalf. They could talk to any business, any insurance agency, pretty much do anything for you. And I mean, I like to say to clients, this is almost like it's just a what if document that you've got in place. Hopefully none of us are ever incapacitated. I mean, that's obviously the hope. But if you are in a situation and if you don't have a power of attorney, a lot of times, if it's you and your spouse and you're joint on everything, the spouse probably will still be able to act for you. But if you're not married, and if you've got children, trust me, the way things are set up now, your children are not going to be able to act on your behalf with anybody, any bank or any insurance company or anything, unless they have some kind of document giving them that authorization. So if you haven't done a power of attorney, and if you've lost competency, if a doctor says that you're incapacitated, you're not able to act for yourself, then the only option they would have is to file a conservatorship proceeding, which, that I think it's in a lot of people's minds because of like Britney Spears. But the reality is that was a situation, just her dad had control over her through a court proceeding. I mean, it's a lawsuit
right.
because, of course, the courts take it serious when somebody, they don't want to take anybody's rights away. So if you have not done a power of attorney and if you've lost competency, that's what your kids would have to do to try to act on your behalf, which is not an easy thing, costs lots of money. So it's way better to have something in place. And the power of attorney, it's the same thing as the wills. They're all revocable. You can change your mind on who you want to serve. And for a lot of those, you have backups. So you could appoint your spouse, and then you could say, as an alternate, I want this child, and then maybe even list another child as a second backup. But just allows you to kind of have people in place that no matter what happens, you've got somebody there.
So
So
a huge misconception with power of attorneys that we run into in our line of business with states where people don't understand that when that person passes, that power of attorney goes away.
all the time I have people call me and say, well, no worries, I'm power of attorney, so I'm going to be able to get in the bank, and after somebody's passed. And
Yeah.
no, that ends upon death. And that's when it switches over to what they call it nowadays in Tennessee is personal representative of the estate. So it's
Right.
just the gender neutral term for executor, executrix, and people don't often know that word unless they've gone through it. But
We
yeah.
just ran into that this last one, personal representative. of the estate. So that's good to know. Gender neutral on that one. Okay.
Yep. And one other thing about that too is, and people think, well, maybe I was power of attorney, and then the person passes, and then they have a will, and they say, oh, well, here's where I was appointed as executor or personal representative, whatever it says in the will. Well, they think they already have authority to act.
Right.
But that, and I don't know if I've explained that good enough, but you don't have that authority until you probate that will. Until that will is made of record, filed within the county, to say that this is the last will and testament. Then the clerk and the judge review it, and they actually grant you something called, if there's a will, letters of testamentary. And that is actually the official appointment where you do become the personal representative that actually has authority to act. And then you have to take that document to like a bank, or if you ever try to sell property or anything, you would need all of that official document. So just having the will itself isn't enough, and you have to go through the probate process.
You have to probate it to make it official, right?
That's right. If if the assets don't go automatically. So yes, that's right.
So let's move on just a little bit. We're getting close to the end here. Inheriting real estate. When someone suddenly inherits local real estate, what is their immediate next step? What do they need to do?
Yeah. So I think that the first thing to determine is how did you inherit it? Was it you and multiple people? Like a lot of times say a parent has passed and it's you and your four siblings inherit it. I would think right then and there, the first thing you need to do is determine, first of all, you know, do you need to file the probate? Was there a will? Did the will say that the real estate needed to be liquidated? Sometimes I have clients through the will, they don't want four kids to inherit a house because they're worried that they won't agree on what to do with it. So a lot of times through the will, they will actually ask that the personal representative, or really require that the personal representative sell the real estate through the probate process, so that then it's just a check getting split instead of four people.
Can I jump in real quick? So,
Yeah, go ahead.
as an attorney that handles you dealing this all the time, what do you think the best way to address inheriting real estate in wills when there's multiple people? Do you feel like it's to sell, split the proceeds? How do you?
What I would
Okay.
say, and this is one of the most shocking things when I got in this area of law. I have two siblings and I'm the oldest, and we all get along great. But I would say in this area, I would say 75% of the people I deal with, the siblings are estranged. And it's sad. It's really, really sad. And even if they're not estranged, maybe they're not close or there's issues. But a lot of times there are issues between siblings. So when usually if there's more than two kids involved, and you're wanting, the real estate to go to more than two people, I have to have a really serious conversation with my clients, and I say, hey, do you see that these kids are going to have a disagreement, or do you already know that one of them wants to keep it but the other ones want to sell it? Well, if you've got that situation, you got to address that head on, because you don't want that will cause litigation. I mean, that would cause problems. So, in that type of situation, I would say you may want to look at asking that it's sold through the process. So then it takes out any chance of argument, and then they're going to split a check.
That's what my dad passed, and me and my brother were best friends. But money can get in. I've seen money just split up families left and right. But we just made it. Hey, we're having an auction, and if you want this item, you buy it. If I want it, I buy it, and we'll split it. So
Yeah.
instead of fighting over the dining room table or the house, if you want it, you buy it. So
The worst type of hate I've seen in my career is sibling hate, which is
yep,
so sad. I
yep,
mean, but I have seen it happens a lot, because especially I think when the parent passes, a lot of times there's a high emotion there. Maybe one of them wanted to do one thing, one of them wanted to
right.
pull the plug, one of them didn't. I mean, that even happens quite a lot. And so then there can be disputes that come up even after mom and dad passes. So it's definitely something I really encourage my clients to think about when they're looking at their will. But I mean, I do have people that give their properties to five kids and say, "Hey, you know what? Let them figure out what to do with it," and that's it. And a lot of times at that point they kind of forced into it.
I
So
think that's kind of mean, but that's true because I've just seen so many families get into it. You touched on something real quick here about pulling the plug. If somebody gets sick. So how important is it to have a living will?
Yeah, living wills are really important. And they, a lot of times I have people that have maybe went through kind of a big surgery, and the hospital has had them execute something there. But I would get that done through an attorney just to make sure you've done it exactly right. But really, a living will, sometimes also called an advanced care directive, is a way that you can put your final wishes down on paper, and usually it addresses three things. Life support, if you would want to remain on life support if a doctor said there was no expectation you getting better, organ donation, and then cremation.
Right.
And what I tell my clients is, if you've got something down where you've kind of said, this is what I prefer, if your family member is in that tough situation where they're having to make that decision of pulling you off life support or not, it is so helpful for them to be able to say, well, here's where mama said what she wanted.
Right.
And then that takes a lot of pressure off of them. And so it's the same as everything else. You get what you want for now, but if you end up changing your mind, you change your mind. And actually the document I do even allows you to orally revoke it. So say you're in the hospital bed and you're not doing good, as long as you have competency, you can say, where I said pull the plug, never mind, keep me on. But yeah, so that they're that's normally the four typical documents you do in estate planning. You do simple will, healthcare power of attorney, financial power of attorney, and living will. That's kind of your basic package. And then of course, like we talked about before, you may want to go a trust route or do something different, which is a little more complex. But that's kind of what I think everybody needs. And you get that in place, you're going to be covered, and it's going to be a lot easier on your loved ones,
Yeah, it
when.
is. We had to go through that with my mom, and one thing I'd like to add to that: if you have a living will, tell your loved ones you have one, so you don't have to. We had to make the decision on my mom, and it just killed us that we had to take her off of life support. But about 2 weeks later, was cleaning out some of her drawers, and we saw the living will where she didn't want to be on one. But so tell your family for sure.
Yeah, I think it's so important. I usually have all my stuff in one folder, and I make sure to go ahead and tell my clients, if they're comfortable, go ahead and share with whoever. You probably, a lot of times, married couples have each other as the primary personal representative, but then they're naming a child as the alternate. Because that's really, like I said before, that's probably the person that's actually going to have to do something upon both of you passing. And I said to my clients, as long as you're comfortable, I would go ahead and share copies of everything with the kids, give them my name. A lot of times I'll even help them email them PDFs so that that person already has copies of everything, because in an emergency type situation, or if you had a medical and situation, you became incapacitated, the worst thing is having to look for the power of attorney.
It,
And they should already have it. That's the whole point of it. So yeah, I hate that you had to go through that, but at least it wasn't the opposite of her wishes. That would have been really bad.
Exactly right. You're exactly right. Well, we're getting ready to end this session, and I just want to say I really appreciate you for taking your time out. I know you're a busy person, and it means a lot to me. And hopefully one day we can do some business together. And but before we leave, future legacy advice. What kind of advice you could give to people? Just for leaving, just whatever your future legacy advice.
Yeah. What I would say to people is, as tough it is as it is, to go ahead and say to yourself, what would happen if something happens to me, next week? Because if you put yourself in that difficult situation, you make sure you're covered, you make sure you've got in place what you would want, and that you're organized, and then you shut a drawer, and you try to not, you don't think about it anymore. I mean, I think I can always see the relief of my clients when they finally come in to execute the documents, because they're done with it, because it isn't a fun thing to think about. Nobody wants to think about their passing. However, there's no better thing you can do than sit and get all of that in place, because it's gonna make things so much easier. So I would just tell people, I really think that there is a fear, like you kind of said before, maybe people think they're going to jinx themselves by doing a will, but that's just not what it is. You're doing is preparation for something that's going to happen, and you're only going to make it better for the people you love the most. So that's all, and I would just say, and one other thing is, to anybody that's just listening to this, evaluate anything you have, as far as if you've inherited real estate from maybe like a grandma or a grandpa. A lot of times people haven't, looked at those deeds and figured out how that ownership would pass. And I would just take time to just reassess what you have, go through and say, what do I want to happen to these assets upon me passing? And it's really important to do that, because I see a lot of issues if you don't.
Well, if somebody's needing a deed, or excuse me, if somebody needing a will or probate, how can they get a hold of you, Leah?
Yeah, so I have a website, tnlawleah.net, that you can find me. You can definitely Google me for Sevier County. It's usually best to send me an email, and then I start with a free initial a consultation a lot of times on the phone. But I do have a number on there as well, and so feel free to reach out. And I'm a one woman show, but I'm happy to help people, and I love what I do. So hopefully we get to work. Yeah, I'd love to work with you sometime, but I appreciate you having me on. This was great for me too, and let me know if you need anything else.
Maybe next time if we do it again, we won't have allergies and sinus.
I know. I cannot believe. I mean, I tell you, I think mine was my nerves. I don't know, because I'm not that bad. I got a little bit of nose stuff going on, but it's like, oh, I want to talk clearly, so now I'm gonna go.
So if anybody out there needs a will or any kind of probate questions or any kind of questions, call Leah up and go see her. Stop by. You're in Sevierville, correct?
That's right.
All right, stop by and see her. Lia Rauber. There you
Thank you so much.
That's right.
That's right.
All right. Well, thanks a lot for joining us today, and hopefully we'll connect soon. Okay.
Thank you so much.
Well, that's a wrap for this episode of Call Us Old Podcast. If you got value for this, make sure you like, subscribe, and hit the notification bell so you'll never miss an episode. Drop a comment below on your thoughts or questions about the auction market. We'd love to hear from you. Thanks for watching, and we'll see you on the next one.